Hello, everyone, and welcome to this lovely Thursday afternoon. I am Heather Quick with the Quick Law Group, and here to talk to you today about attorney's fees in divorce cases. That is a question that comes up so often, and there's a lot of different answers. It's not just a yes or no. There are many factors that go into the issue of attorney's fees. And we deal with that a lot and have those questions from the very beginning, from the first phone call into our office up and through trial. And I had a hearing this week, and some of my other attorneys had some issues come up, and we had this discussion. I thought it would be a good topic to share with you today, as I know those questions are always out there. So as it, in divorce cases, the law provides that they want there to be equal footing for the participants in a divorce case, and historically and traditionally, and in fact, it still happens so often today. But one person has control of the finances, and one person may be at a disadvantage because they don't have control of that money. In those cases, what the statute in Florida provides that the court shall and may award attorney's fees to the other party. Now, this is, if I haven't heard this once, I've heard it 100 times with so many of our clients. They ask, well, I heard my friend at the very end, the attorney didn't charge them, and at the end they got the attorney's fees from the other side. Now, it's not that I doubt that, and that is the way it happened back many more years ago, and we didn't have the structure of the equitable distribution that we have now, and those were different times, and the case law was a little bit different. But now we have several issues to look at, and so I wanted to share that with you all. Because I know it's a question that comes up a lot, and many times you'll ask the attorney, they're like, well, I don't know, and let me give you this answer. So that's why I want to give you some basic, maybe guidelines that will help you understand the process in Florida when you're going through divorce and have questions about attorney's fees and who's going to pay and why don't they have to pay for all of it. So here's kind of the lowdown on that. Now, the Quick Law Group, we represent women and work with women going through divorce in Florida, both here in our Jacksonville office and Winter Park. Now, with that being said, I will tell you still, very often I see that the husband is still the primary breadwinner. That's not to say that many of our female clients aren't business owners and the major breadwinner in the family, but there's still a large portion of them. Of our clients that do rely on the husband to bring the majority of the money into the household. And so there's a concern. They want to hire a lawyer. They're ready to move on and file for divorce, but they're concerned they don't have the funds. So they're going to come to us, and they do come to us all the time and ask, well, how am I going to pay for attorney's fees? Can you just make my husband pay? And the short answer, and it's just yes and no, because most law firms, and really all law firms and any law firm that you're going to go to in the state of Florida, is going to require and should require retainer agreement and really outline for you what the fees are going to be and require you to pay up front. Now, we work with clients on strategic ways and different creative ways to get that initial source for the retainer if the husband has 100% control of the money. But the reason you want a firm to really require you to pay up front, and that is going to charge you, is because one, that means they are a good business and they're in business and they're functioning. If you are hiring a lawyer who's not going to charge you or waive your fees until later, I would just be concerned that maybe they don't have enough business or they're not really sure how to run their business, and you could end up in a situation where they've gone out of business, so you don't have representation. And the Florida Bar does require a retainer agreement between a client and their attorney, and again, that's good business. So I strongly encourage you to expect that when you go see an attorney. And during that initial stage, many times I hear, well, we don't want him to see it on the credit card statement. All right, there's some creative things that we can do there. And it just depends. Some men, husbands, wives, but some very many men that when we're representing them, we hear that they check the bank balance every day and the check cards. They're very, very controlling in terms of money and financial controls. And I will tell you, just so that you know, if you're in that situation, that's not normal. But it is common, and don't be embarrassed that you're in that situation. It is typical of a very controlling personality. And I talked to this amazing woman once who's, a great teacher and leader in the terms of finances. And she said it's just financial abuse is what it is. Our court system is really, really behind in recognizing and appreciating all of the types of control and domestic violence and abuse that do occur and can occur in marriages in a variety of forms. So many times it's hard to really look at and understand emotional abuse, verbal abuse, because it's very difficult to prove because it's just between two people, and the financial abuse, and some individuals don't always take that seriously. So it does exist, and it does pose a problem for clients who really want to retain an attorney, but are concerned for their safety if their husband sees the charge on the credit card, and are trying to follow some of my tips as far as don't tell them ahead of time. Allow us to strategically prepare for when you're ready for them to know you're moving forward. That being said, what we can do in that case is a lot of times you can apply for financing and go outside the marital funds to get the money for the attorney's fees. And that is, what a lot of women have to do. They have to rely on family support. And that can be difficult. Just asking for help can be difficult, but you'll be surprised as to how many of your family members are maybe probably waiting and have been hoping you were going to do this for quite some time. So you'll see maybe more support than you realized. And that's just to get you started. So when we delve into the issue of attorney's fees and are you going to get that paid back, who's going to pay for it? So let's look at the debt. And when we will advise, and routinely I say, you hold on to your cash, because if they're going to cut you off, potentially, be careful, hold on to that cash. You're going to need to pay bills and pay gas and buy food and pay your electric bill and whatever. So if you have credit available, it is best to charge it. And then that will be considered marital debt. And is generally going to be split between the two. So he will be essentially paying for part of the attorney's fees. And secondly, where we are now, the jurisdictions are different, and by jurisdictions I mean the counties and areas here in Florida. So in the Winter Park, Orlando area, Orange County, you cannot go in court for a motion for temporary attorney's fees until after mediation. And that's costly, and that requires a lot more strategy and planning on our part for those women. But it is it's important to know that. But now here up in Northeast Florida, we are able to schedule motions for temporary attorney's fees. And that's where we tend to prevail more often than not, because we are in the middle of the case. And each party is entitled to representation and have fees paid, especially also when we may need experts. A lot of times there are experts necessary for forensic accounting and helping us with the financials. In the cases where many women are concerned that the money is being hidden. And I hear that a lot. And I think that's a valid concern. You feel like there is more money, and has he hidden money? How am I going to find it? Then we have to do an evaluation. How much could be there, and do we have the money to find the money? Which is a difficult decision, but it's an important one, because it helps you make the right decisions as far as what those beliefs are, what basis do we have to go look for it, and let's try to figure that out. And that's when we would hire a forensic accountant. You're not going to be able to do that without an award of temporary attorney's fees. So those are the things we look at in the beginning of the case. It may be that their husband has all the money. He's restricted access to the accounts. So in that case, we will absolutely go into the court and ask for temporary attorney's fees. The big key is knowing that the money is there to pay it. And a lot of times you don't know that going in if you don't have access or an understanding of your financial situation. I don't want you to feel as though that puts you at a disadvantage or embarrassed about it, because that's what I see most of the time. Women are so, they just really don't want to share that information. They're embarrassed that they don't have more knowledge and or control over the finances. That is, it's very common. It's just very common. And, rather than stay in fear and in shame about it, let us help you, because we can use the court system. We can help you, one, get the information, because then that can be very liberating, just knowing the financial situation. Sometimes it's going to be maybe scarier than you thought, but hey, at least you know, rather than keeping you up at night or just that uneasy feeling inside, like how much debt are we in, how much money is coming in, and is there money to pay for attorneys? So often, so much fighting and disagreement throughout the case is going on, and a lot of money spent on attorneys. And I wish that it could always be so easy as to come to an agreement, but we're dealing with, the things that are most precious to most people, which are your family, and then your finances, and then, of course, your emotions with someone who you've been very close to. They also know how to push your buttons and hurt you as much as there was the love at one time. So money, is really how we have to fund the entire operation. And a lot of times at the end of the case, so even if we've received temporary attorney's fees, which we do in the cases that it makes sense to do, we will do that. We look at a lot of things, and you should be asking yourself, your attorney, where's the money going to come from? Because I don't want to go spend money to ask for money that doesn't exist. And that would be my advice. Like, let's look for it and know where are we going to ask for this money to come from on a temporary basis for attorney's fees, when we may, really be experiencing, trying to find the money to pay for temporary spousal support as well as child support. So we look at all that. Now, when we are going to trial, this is where the law has the case law that exists, and that's what we have to help plan our strategy, and we advise our clients based on decisions that the courts above the circuit courts. So things are appealed. That's how case law is created. That is basically the laws that we have to abide by and how the law is interpreted. The beautiful thing about the law is it's not black and white, and there's usually, you can differentiate on facts and find things that are in your favor many times, and then differentiate the cases that aren't. So that's something that we do a lot in looking at issues of attorney's fees. But when we go to trial and when everything is going to be divided, the job of the court, and this falls a little bit under how property and assets and debt are split, it's supposed to be 50-50. A lot of times when it's not, so, for other reasons that I'm not going to get into this time, but I'll do another talk on premarital property, inheritance, things that aren't going to be divided in the middle equally in Florida. But they are. So when we are at trial, we may say, hey, judge, our client has spent $30,000 on attorney's fees. We want the husband to contribute to that. The way that the court may determine that is by dividing the debt. So maybe part of those attorney's fees were incurred in the debt, so he's going to have to take some of that debt, dividing the assets, and then generally awarding alimony. And then what the court's looking at is, can we get these parties on equal footing? And, it's not always equal. Usually in the debt and assets it is, but the income's not going to be split in half. And it's just not, that's not the way the law is. And so, very often it may not be exactly equal, but the court has what they consider equalized the parties and distributed or address the issue of attorney's fees during that time. And that's important because you want to really look at, if you have to go to trial, a lot of cases settle at mediation, that's great. I like to talk about what happens at trial because I think that's the way we determine and advise clients on whether or not this is a good idea, a good settlement, this is something that's going to happen. Don't fight it because you're going to lose, or they're compromising on an issue that you may not succeed at in court. And that's a good thing. So it's very important from my perspective to understand what's going to happen at a trial and how things will be awarded. Many times, if you have a debt, say you've incurred much more debt in order to pay for your attorney's fees, the judge will take that into account when looking at a spousal support. Has no bearing on child support. Child support is going to be ordered based on your husband's income, your income, how many overnights, and child care. So those things, even though at the end of the day, the money you're going to receive on a monthly basis is going to be what you need in order to survive and pay the bills and expenses, part of which may be debt incurred for attorney's fees. You want that to definitely be brought up at the trial level so that it's addressed. It's not necessarily a windfall. And again, it really is going to depend on each case. The more money that's there that your husband may make or that you guys have put aside, the more likely it is that the court's going to allow that money to be awarded back to you for attorney's fees, or in the interim, as we were talking about before, like as you're planning, because experts need to be paid. And in cases where we have, a lot of valuations as far as businesses and several companies, that can happen so often where even maybe both the parties have a lot of different companies, investors in companies, maybe have various corporations. A lot of rental properties, there's a lot of that goes on. And so we really have to do a detailed analysis. And sometimes we really need a forensic accountant because not all properties created equal. That's going to be out-of-pocket costs that the court typically will award ahead of time that the husband does have to pay on behalf of the wife if he is the primary breadwinner or has access to more money than the wife does. So when you are contemplating divorce, or if you're in the middle of a divorce, just got out of a divorce, attorney's fees are a painful issue because it is expensive to go through the process. One of the things that I think is very helpful, and the judges look at this as well, so I think that's why it's wise to bring it up. If you've ever heard this phrase, you got to have some skin in the game. I've heard many judges say that. Will be arguing that husband should pay 100% of mediation, of an evaluation, of fees. The courts, I've been in front of many judges before, said, well, no, I may apportion it based on where they are income-wise, and that could even be 80-20, 90-10, 50-50, 60-40, doesn't matter. But the courts say, listen, you have to, I want each party to be participating in this so that they do feel the pain. Because it's painful to pay your attorney, and I can say that. I'm an attorney, and I understand that. You need us, but you really aren't wanting to be in the position of needing us at that time. But it's necessary in order to get through the process and get the results that you need. It's too important to go without. It will cost you far, far more down the road, and at the end of the day, if you don't have adequate representation, especially in cases of child custody and alimony and child support. It's just, there's too much at risk and there's no going back. So it's one of those things you have to have that. Now, I have very, very rarely had clients that were, maybe didn't really want to settle, could be portrayed as unreasonable. Most of the time, I think the other side's a lot more unreasonable than we are. But I got to tell you, when you are footing the bill, we talk in all of the Quick Law Group and all of our locations and attorneys, very candid conversations with you about what this is going to cost and is this going to get you closer to your goals. And I would strongly encourage anyone involved in this process, going through it now, contemplating it, make sure you're having those conversations, because you can do a lot of work on a case and just do discovery, do depositions, just do a lot of work that's going to be very costly for you. And it may not get you closer to your ultimate goals. And I understand clients, you want to depose that, you want to take the deposition of the new girlfriend or the doctor or employees of your husband's company in order to find something out. And when you ask your attorney these things, we are problem solvers, and we like to discover information. So we're going to be like, yeah, we'd love to go do those investigative things and look for these information. But what even in our firm, although we want to go do those things and solve them, we're going to ask you, is this going to get us closer to your goals? And do you understand that? Because that is the most important thing, is really, where are you going in this? And are we driving in the right direction? Because we can take many directions. And, some longer routes, just like the toll roads, they cost a lot more, but they, maybe glide through a little bit faster without as much aggravation. Some roads, may be full of gridlock and it's just more painful, takes longer, less expensive. I'm not saying that's the way for each time, but it's just an important discussion. And we at the Quick Law Group really look at that and challenge our clients. Like, let's really think about, how are we going to get you where you want to go? And let's be on board with this strategy. And I think that all clients and all attorneys should have that discussion. And so, part of this is to dispel the myth that at the end of the day, the husband's going to pay all the attorney's fees, because that's really not going to happen. And it could, and it doesn't mean we're not going to ask for them, but I, always want my clients to know that have realistic expectations. We've done this so many times. We can predict with a lot of certainty what is going to happen. So let us guide you in that way and make educated decisions that are reasonably calculated, understanding the risks and benefits, so that at the end of the day, you reach your goals and, you're overall satisfied with that. And it ended up close to what you expected. And hopefully not, putting you and your spouse through bankruptcy. Doesn't have to be that way. And part of that is really having those open discussions and understanding the costs of the whole process, and who's going to pay for it, when it's going to get paid, and how that's going to affect you in the future. So I am happy to answer any questions that you post on this video. We will respond. And I thank you for watching. Please, if you are a woman who needs help and wants to work with us going through your divorce or post-divorce issues, alimony, prenups, postnups, please contact the Quick Law Group. We have our offices in Winter Park open, as well as Jacksonville. And we will post the link for the office. You can contact us online or call us at 904-241-0012. Thank you all. Have a great day.